One missed clause. That's all it took to lose $3.8 million. An investor had what he thought was a perfect trust. His lawyer approved it. Everything was signed and funded. But when a lawsuit hit, one missing sentence meant the courts could reach in and drain millions from the family's estate. That clause? A spendthrift provision. Without it, the judge ruled the trust provided no protection. No one had done anything wrong. The problem was silence, outdated language, a blind spot that cost nearly $4 million. And here's the real concern. That same blind spot could be hiding in your documents right now. Let's be direct. Most high net worth individuals believe their assets are protected. You may have an LLC, a trust, maybe even insurance. But if your planning isn't updated, integrated, and defensible under current law, it's not protection, it's decoration. This is smart modern wealth. And today we're breaking down how serious families build legal firewalls, quietly, preemptively, and permanently. This is not financial advice. It's a review of what the wealthiest families are already doing. If your net worth is above $5 million and you own real estate, operate a business, or invest in private markets, this is directly relevant because today's environment isn't neutral. Litigation is rising. IRS enforcement is intensifying. And most protection plans are only 90% complete. That last 10% is where the risk lives. Let's walk through 5 real-world strategies that sophisticated families are using to lock down their wealth, and the small errors that make them fail. 1. Domestic Asset Protection Trusts, DAPTs. This is the foundation. A DAPT is an irrevocable trust, often set up in states like Nevada, Delaware, or Alaska. You transfer assets in. You're still a discretionary beneficiary. After a seasoning period, typically 2 years, those assets are largely shielded from creditors. Used correctly, it's one of the most robust legal barriers available. But its effectiveness depends on your state of residence, the trust's jurisdiction, and precise execution. A DAPT set up in the wrong state or with the wrong trustee may not hold up in court. Second, LLC layering and charging order protection. Many real estate investors use LLCs. Fewer understand that where the LLC is formed matters deeply. States like Wyoming, Delaware, and Nevada provide stronger protections. Creditors can't force distributions or seize control. Best practice? Use layered ownership. The operating asset sits inside an LLC. That LLC is owned by a holding company. The holding company is owned by a trust. Each layer adds complexity for outside claimants. Done right, it builds a defensive perimeter. But that perimeter only works if each layer is compliant with state law and properly maintained. 3. Private Placement Life Insurance, PPLI. PPLI is underutilized and misunderstood. It allows you to hold private investments, hedge funds, credit funds, private equity, inside a life insurance policy. Here's why it matters. Assets grow tax-deferred. In many states, they're protected from creditors and they pass to heirs income tax-free. PPLI isn't for everyone. It requires underwriting, customization, and the right capital level. But for families seeking privacy, control, and legacy efficiency, it's a powerful, compliant solution. 4th, Family Limited Partnerships, FLPs. FLPs offer central control and multi-generational alignment. As the general partner, you manage the assets. Your heirs hold limited partnership interests. This structure allows for valuation discounts for gift and estate tax planning, restrictions on distributions and voting rights, and long-term continuity of investment philosophy. FLPs aren't new, but their strength is in how they're tailored, defined by the quality of their operating agreements and their alignment with other planning tools. 5. Captive insurance companies. Captives are lesser known, but used by serious business owners. You create a licensed insurance company to self-insure your own business risks. Premiums are deductible. Reserves grow tax-deferred. Surplus can be accessed strategically or passed to the next generation. Captives aren't loopholes. They're legitimate under IRS code when implemented correctly. Misuse, however, brings penalties. This is a tool that requires coordination with tax counsel and actuarial professionals. Let's return to that opening case. The trust had been drafted years prior. It looked complete. But it lacked a spendthrift clause. the one sentence that bars creditors from accessing trust assets. The judge didn't rule on intent, he ruled on language. Without a clear restriction against involuntary transfers, the trust offered no shield. And when plaintiff's counsel discovered the trust, they filed a charging order. The door was already open. That single omission, one clause, was all it took to lose nearly $4 million. This happens more than most realize. Not because wealthy families ignore planning, but because planning is siloed. A lawyer builds a trust, a CPA handles taxes, an advisor reviews allocations. But no one integrates protection, tax, estate, and litigation strategy under one lens. And in that gap, wealth evaporates. So here's the truth. Asset protection isn't about paranoia. It's about positioning. The ultra-wealthy don't just build wealth. They structure it, shield it, and future-proof it. Long before there's a problem. Smart modern wealth means questioning everything, even the safe stuff. You just saw how one missing sentence cost millions. But here's what else we found. Business owners are losing hundreds of thousands in their 401ks the same way. The wealthy stopped using them years ago. We'll show you what they use instead. Watch now.